Thank you for clicking on this video of the Commercial Receivers Association. We are very privileged and pleased to have today one of the preeminent receivership attorneys in the state of Texas, Marc Spector. He's going to go over with us the basics of a commercial receivership in Texas. There will be a link to his bio and contact information on the Texas tab of the CRA website. Mr. Spector, for those of you who have not met him before, has practiced insolvency law since 1992, and he's regarded as one of the leading and most experienced and highly regarded commercial receivership attorneys in the state of Texas. He served as counsel to large multinational clients, as well as to smaller firms and individuals. He's been on the debtor and the creditor side of the table. His practice focuses on middle market and small business clients seeking advice on how to restructure liabilities in challenging business environments. He has experience, as I mentioned, as both a debtor and creditor's lawyer, which allows him to tailor his advice to clients no matter where their interests lie. And for our purposes, it's important to note that Mr. Spector serves as a receiver for courts around the state of Texas and assists in rehabilitation, stabilization of the assets placed into receivership, orderly liquidations where necessary. And he's served as a receiver for a variety of companies across a broad spectrum, including trucking companies, energy companies, manufacturers, heavy equipment resellers, multifamily housing owners, and individuals also whose assets are under court supervision. And so we're very appreciative and very honored to have Mr. Spector taking the time today to help provide some commercial receivership basics for the state of Texas. So, Mr. Spector, thank you so much and welcome.
Well, thank you for having me.
So in order to get right into it, I think that what we should first give folks an idea of is, from a very high level perspective, how does commercial receivership work in the state of Texas?
So a commercial receivership is a remedy that is part of a lawsuit filed in a district court or a county court of law here in Texas. Almost always it's filed in the district court, but in theory, it could also be filed in the county court of law. And it's either made by separate motion after the petition is filed or as part of the petition itself.
So in Texas, is it permissible to seek a receiver as a standalone remedy, or is it always associated with some other claim?
You can seek it as your only remedy in a petition, but you have to seek it in the context of the petition. In other words, okay, you could seek it as a remedy. You want a receivership and not have a suit on the note in your petition, but you at a minimum have to have a petition. There's no such thing as an ancillary proceeding without a lawsuit backing up.
Okay, and that lawsuit, you need to allege some other claim, not just receivership. You have to allege a claim that's a contractual or tort or some form of claim.
You have to allege standing to predicate your right to a receiver, but no, you don't have to sue on your claim in the same suit.
Okay, very good.
So the only cause of action could be a cause of action for a receiver.
And to have a receiver appointed in Texas, is there an in-depth statutory scheme that helps judges and practitioners, or is it largely common law based?
So in the early 1900s, it was all common law. There was no statute. And that common law forms the basis of the statutes that now exist. There are really two schemes for receivers. There's the Business Organization Code, which itself has three different types of receivers embedded within it. There's a receiver over property under section 403. There is a rehabilitative receiver under 11404, and there is a liquidating receiver under 11405. Outside that Business Organization Code scheme, there is also a provision of the Texas Civil Practice and Remedies Code, which is Chapter 64, that sort of overlays receiverships under the business organization code and ones that don't fall within the business organization code.
So if you were to commence a receivership under the rehabilitative code and the rehabilitative process fails, is there a conversion to a liquidating receivership somehow? How would that work?
There's a finite time period set forth in the rehabilitative statute. And at that point or earlier, the receiver or another party can seek authority to liquidate and invoke the remedy under 405.
Okay. And so
the confusing thing for, I think, many people here in the state, including myself, is that even though you are under the business organization code, you still look to the civil practice remedies code for matters that are not specifically addressed in the business organization code.
And so let's take a circumstance where you go in for a receiver under a rehabilitative type of a scheme. And I assume you can be a creditor and do that. You're trying to get eyes on, get visibility. How extensive is the appointment order? I've seen orders, for example, that are very detailed as to what the receiver powers are. And I've seen orders that are kind of general in terms of the authority. Where does that land in Texas?
I would say it tends, the prudent practice is a very, very broad order. And by broad, I don't mean short. I mean detailing every single power you want the receiver to have, because the common law does not really delineate what receivers can and can't do. And moreover, it doesn't really delineate what acts the receiver would have judicial immunity for. So I think the prudent practice is to make a very, very extensive order specifically describing everything you want the receiver to be able to do. For example, my receivership orders almost invariably provide the power to act as attorney in fact for the receivership entity. They almost invariably provide me with all of the authority that the board of directors have or the managers have in an LLC. It has the power to redirect the mail, to open the mail, and these are all specifically described in the receivership order, because without that, there's really no body of law that says, yes, a receiver can open the mail, or yes, the receiver can enter into new contracts on behalf of the receivership entity.
So are there available to practitioners forms of order that you can consult that are available either through the state bar or somewhere else? Or is it just necessary? You just need to get someone who knows how to do it.
Yeah, I'm not aware of any library of forms. I mean, I've developed a library along with others who practice in this area, and we're constantly updating the relief we seek based upon prior cases. But I'm not aware of any sort of resource that's available through the state bar or the courts on what a traditional receivership order would look like.
Now, these lengthy orders coming into a case that is a fairly niche practice area suggests that there are likely judges who have very limited experience with this kind of an elaborate order or with receivership generally. How are the courts in Texas in terms of their experience with receivership and insolvency law principles? Do they have a lot of experience? Is it an educational process sometimes?
So I think our judges are very used to seeing receiverships in the context of collection efforts by creditors against individuals. Receiverships for example, an oil and gas interest, or receivership, or receivership for a trust, if the trust has a creditor. We have a very sophisticated bench here, but as a general rule, I think they're used to seeing receiverships in the commercial context, although it's not something that they see every day or likely even every month.
Okay. And so let's flash forward to once you get your appointment order entered, who can appear in the case? Can any creditor come in, or is it only named parties? Is there intervention required? How does participation of stakeholders, how is that governed?
Yeah, I mean, that's come up a few times, and obviously courts want to be accommodating to the legitimate interests of creditors. But because the receivership is a lawsuit and there's no special process that governs receiverships, there's no way to really appear in the lawsuit other than intervening. Now, as a practical matter, in Texas, we do not have, you don't need to seek leave to intervene. So you just file your petition and intervention as a matter of right, and you're in the case, subject to the judge deciding that the judge considering a party's request to strike the intervention. But I've never seen a creditor intervene in a case and have that intervention struck.
And if the receiver appointment order is entered, is the receiver obligated to gather information and give notice to all creditors and other stakeholders, real or potential, in some fashion?
No, the receiver is obligated to do what the receivership order says. And oftentimes the receivership proceeds, for example, to marshal a secured creditor's collateral and liquidate it without notice to unsecured creditors. That said, unsecured creditors often find out about the receivership because the receiver becomes the controlling party for the business, and certainly is again a matter of prudence. I make the receivership very visible to the unsecured creditors. I tell them whether there will be a claims process for unsecured claims based on whether I believe there will be assets to administer for the benefit of unsecured creditors. But to straight answer to your question is no, there's not an analog to the bankruptcy process where you provide notice to the field of creditors that exist or publish notice.
Okay, and you mentioned marshaling and liquidating assets, although I imagine even in a rehabilitative receivership, if you're selling off a business division, there could be asset sales. Are free and clear sales permissible in Texas? And
no, they're not. There's it's just a straight UCC process. There's no way to force a junior and even wholly unsecured creditor to release its lien. Now, there are mechanisms that can accomplish that, but they're not significantly different from what you would see outside of receivership. For example, with junior real property lien holders, I have coordinated a non-judicial foreclosure sale with the buyer, which extinguishes the junior liens, knowing that my bidder was going to be at the foreclosure sale and bidding the agreed upon purchase price. Same thing with tangible personal property. We can, structure a UCC sale where the bidder is in attendance and bidding the agreed upon purchase price and extinguish junior liens that way.
And in that process, obviously there's litigation, there's some acrimony. Are buyers, in particular, I'm thinking of buyers of real estate, are they satisfied with the form of deed that they get? Are title carriers satisfied with receivers' deeds in Texas, or is it a foreclosure deed?
It's a foreclosure deed. They're satisfied with receiver's deed if they're satisfied with title generally. I've conveyed many properties out of receivership, but I've never done it with a a short sale and junior liens hanging on because, again, there's no free and clear provisions under the Texas code.
Okay. One distinction I've noticed, I've conducted a couple of, a variety of interviews in some other states, and one distinction that I've noticed, it relates to bankruptcy. And and it may be the case in other states as well, but provisions are not uncommon in Texas appointment orders, pursuant to which the court somehow affects the receivership target's ability to file bankruptcy, either by vesting that authority in the receiver or perhaps vesting it only in the receiver. And I know that there's case law going either way. How have you ever seen a circumstance in which a debtor has filed a bankruptcy case effectively contrary to the receiver's appointment order? And if so, what was the outcome?
So I've never seen that particular circumstance in Texas. I know of two cases where the receiver's authority to file was challenged by the management. So the receiver in that case filed the bankruptcy petition, and then either a creditor or management challenged the receiver having authority. And in those cases, I know that the receiver's authority to file the case was upheld. Okay. Because the courts in those cases, determined that the receiver was vested with all of the management authority under state law, which included the authority to file. Now, you're sort of asking the inverse of that, which is, right, does that mean the management can't file? And I'll tell you, as a bankruptcy lawyer, I have very, very mixed feelings about taking that privilege away from the debtor and the debtor's management simply by virtue of a collection remedy employed in state court. I personally think that the best answer is that receivers should be authorized to file, but that shouldn't take away from management's ability to file it either. Mm-hmm. And that's sort of where I come out.
Yeah, it'll be an interesting topic if there ever is an order which does set up that inverse kind of circumstance, because I think I would see it the way you do if I had to kind of shoot from the hip, and that's kind of the concern I would have as well, is can you really take away someone's right to file bankruptcy as a remedy? So I guess we'll see one of these days that may end up getting resolved one way or another. So look, I as I said at the outset, I really appreciate you taking the time to do this. This is very educational. It's fascinating to me, I'm sure to others practitioners, to see the differences in the different states handling what is effectively the same receivership type system, but in very different ways. And it's been evolved in a very kind of interesting set of circumstances, which I think just behooves people to get in touch with an expert, a practitioner who knows the field in the state that they're working in. And so it's a great advantage to me. It's a great advantage to everyone who will watch this video to have you on and to share these insights. So I appreciate it very much. And thank you so much for taking the time to share your expertise here.
Well, again, thank you very much for having me.
All right.